asked if they could be fair in this case, and if they reserved any bias either against or for the petitioner, which none of them made this indication. Upon reading the verdict, two of the jurors approached defense counsel, being that one of the other jurors had brought up and made racially biased comments against Peña Rodriguez.
Counsel, we've read the record, we know the facts. So what relief do you want from us here today? What do you want us to do that goes beyond what we've already done in Tanner and Warner?
Well, the issue with that, and I guess to offer a solution addressing the Tanner and the Warner cases, the Colorado Supreme Court has acknowledged that neither of those two cases involve the exact issue of racial bias. And I suppose that a possible solution would to indicate to jurors that if they were to encounter during deliberations any sort of bias, be that race, on gender, anything, to go ahead and let the judge or perhaps even one of the counsels know of that before the verdict is read. That way it can be addressed without having to wait for the verdict to be read, because that's also a major issue in a lot of these cases.
What do you want for your client?
For our client, we are moving for a new trial. He was not given one on the state that, due to Rule 606B, that the deliberations were protected. And in this case, say as has been mentioned earlier, he made several racially biased comments, and I understand that the judge had indicated that with the jury that they had, that there was going to be some problems with bias against illegals. However, that really does not apply that well in this case, being the juror in question made 5 different comments, and only one of those comments actually addressed an illegal residence. However, the comment was the alibi witness was not credible because, among other things, he was an illegal. However, during the case, the alibi witness had testified that he was in fact a legal resident of the United States.
So, counsel, you're proposing that the court admonish the jury before the jury goes into its deliberations or when the jury is first impaneled, that if they experience any racially biased statements in the jury room, that they are to report it to the judge.
Yes, correct.
So what happens if that happens in the middle of the trial? Does that result in a mistrial? Do they have to get a new panel? Do they have to interview all the jurors? I mean, how does that work in terms of just the administration of justice?
I do understand that it would be very inconvenient, especially for the jurors who are taking time out of their lives, away from their families, away from their jobs, to come and be on this jury. However, it does need to be respected that a defendant does have the right to an impartial jury. And again, a big issue is that, I suppose, in this case, if one was to be preferable, I would rather that the issue be addressed during the trial or even in the middle of the trial, rather than waiting till the very end when all the arguments have been made, the verdict being read, and then having to decide, well, we need to do this trial all over again because we waited too long for the issue to be addressed.
So let's say that